On October 10th, 2024, Patrol Officer Lachlan Hicks of the Lowell Police Department stopped driver Cynthia Sanchez Rosas in Lowell, Arkansas for allegedly driving 40 miles per hour in a 25 mile per hour zone. The encounter was captured on both Officer Hicks' body camera and dash cam.
13 traffic. Be on the west side of JB Hunt Corporate. 911 Zebra St. Mary. It's a blue Honda. Damn. Hello. I'm Officer Hicks, Lowell PD. I'm stopping you for doing 40 and a 25.
40 on a 25?
Yes, ma'am.
That's not true.
It is true.
That's not true.
Okay. Do you have your license and insurance?
Do you have the,
Do you have your license and insurance?
I do have my license and insurance.
Okay, please produce it.
Do you have the evidence where I was running 45?
Please produce your license and insurance.
Do you have that?
Next time I have to ask, I'm going to arrest you for obstructing governmental operations.
You can't arrest me for
Yes,
that.
I can if you don't identify.
But do you have the...
Okay.
I will. I will.
Right. Step out. Nope, you wanted to play
Amber?
games.
Hold on.
Nope,
Hey,
you wanted to play
you can't
games.
do that.
Yes, I
Hey,
can.
you can't do
You wanted to play games?
No, no, no.
Get out.
Hey, you
Get out of
can't
the
do
car.
that. No, no, no.
Get out of the car.
No. Hey,
Get out of the
I'm
car.
giving you my...
Get
I'm
out of the
giving
car.
you my ID.
Get out of the car.
I'm giving you my ID.
1394. Get out of the car.
I'm giving you my
Get out of the car.
I asked for proof. I'm giving you
Get
my
out of the
ID.
car or you're going to get
You don't need to do
tased.
that. You don't need
Get
to
out
do
of the
that.
car.
Hold on. You don't need to do
13,
that.
I got one trying to block me from the seatbelt.
I'm not trying to block you from the
She wouldn't let me get her out. She's
hold
just
on,
not
hold on,
listening
hold
to
on, hold on.
instructions. She's probably about to get tased.
No.
Get out.
You don't need to tase me, dude.
Get out.
Hold on.
Get out now.
Hold on. You don't need to tase me, though.
Get out.
And I'm coming back to work,
Get out.
man.
Get
You
out.
don't need to tase me. Hold
Get
on.
out.
Dude,
Walk
I don't
back
need
this
to
way.
Hang up the phone, though.
13,
Hold on.
she's out.
Hold on.
Yes, put
Hold
your
on.
phone down.
You
You're
don't-
not.
no,
Shut
I-
up.
I just
Shut
wanna
up.
talk-
Shut up. I'm done with you talking over me. Walk that way.
For what?
Now.
What for? Hold on,
Turn
hold
around.
on. No. You don't need to forcefully. No, hold on.
You're
hold
gonna
on,
get
hold
taken
on,
to
hold
the
on.
ground.
Hold on.
Stop.
Don't do that. Don't do
Stop.
that. Hold on, man.
Stop.
Hold on. Oh! No, I'm not doing it. Dude.
You can't resist.
I know, but dude, I gave him my ID.
resist.
I gave him
You
my
can't
ID.
resist.
I gave him
You
my
can't
ID.
resist. You
I
can't
know,
resist.
dude, but I gave him my
I
ID.
know, just stop.
Like, I gave him my ID. Hold on.
I know, just stop.
Hey, can you go tell Amber that I'm being taken, please?
Yeah.
Yeah.
Okay.
And my ID is right there. I need my phone.
Just calm down.
Yeah, but like,
It's right
14.
I know, but like, I gave him my ID. I asked him for proof that I was going 45 on a 30, which I wasn't.
You made that way bigger than it needed to be.
Yeah, but I was not going 45 on a
Get out.
30. This is not necessary, man.
113, log 1 resisted.
I was not resisting, dude. I gave you my ID. I was not going 45 on a 30. Dude, I'm getting back to work.
Not anymore, you're not. You're going to Benton County.
Oh my God.
You work here.
Yeah, I was not going 45 on a 30.
You're doing 40 and a 25.
No, you first said 45.
No, I didn't.
Yes, you did.
You can
You
FOI
have
the
it?
body camera.
Okay. And I asked you for proof.
You're under arrest.
Okay,
You're under arrest for obstructing governmental
I
operations
was not obstructing
resisting
nothing.
arrest,
I was grabbing my wallet.
and speeding.
I was not speeding either.
Sit down. Your car's also getting impounded.
Officer Hicks informs Ms. Sanchez Rosas that she's under arrest for obstructing governmental operations, resisting arrest, and speeding. Ms. Sanchez Rosas disputed the alleged speed throughout the encounter, but unfortunately, the lawfulness of the underlying stop and the speeding charge cannot be assessed on the available footage. Accordingly, we will assume, for the sake of argument, that the stop was supported by at least reasonable suspicion. Under Section 27-16-601 of the Arkansas Code, a driver is required to produce their license upon demand by a law enforcement officer during a lawful traffic stop, and that obligation is not conditioned on the officer first demonstrating the validity of the stop to the driver's satisfaction. Additionally, the Supreme Court held in the 1977 case of Pennsylvania v. Mims that an officer may, as a matter of course, order the driver of a lawfully stopped vehicle to exit the car, and that authority requires no individualized suspicion beyond the lawful stop itself. Therefore, a court would likely conclude that Ms. Sanchez Rosas was legally obligated to both provide her driver's license and step out of the vehicle, presuming that the underlying traffic stop was supported by at least reasonable suspicion. However, this does not necessarily mean that her delay in complying with these orders constituted obstructing governmental operations. According to Section 5-54-102 of the Arkansas Code, a person commits obstructing governmental operations when they intentionally obstruct, impair, or hinder the performance of a governmental function by a public servant acting under color of law. As the Arkansas Court of Appeals explained in the 2026 case of Keaton v. State, the statute requires actual interference with law enforcement operations, meaning that passive or minimal noncompliance may not be sufficient to sustain a conviction. Now here, a court would analyze whether Ms. Sanchez-Rosas's delay in providing her license and stepping out of the vehicle obstructed, impaired, and hindered Officer Hicks's ability to perform his governmental function as a law enforcement officer investigating a potential speeding violation. Additionally, the physical struggle after Ms. Sanchez-Rosas exited the vehicle potentially implicates two distinct so-called resisting offenses under Section 5-54-103 of the Arkansas Code. Under subsection A, a person commits so-called resisting arrest when they knowingly resist a law enforcement officer effecting an arrest by using or threatening physical force or any other means that creates a substantial risk of physical injury. And under subsection B, a person commits so-called refusal to submit to arrest when they knowingly refuse to submit to arrest, whether by active or passive refusal. Accordingly, a court could conclude that the physical struggle between Ms. Sanchez-Rosas and Officer Hicks constituted a violation of one or both provisions of Section 5-54-103.
The warning symbol, I worked on the Taser. She got out, and then I said, hey, walk over this way. She's like, why? And she's like, I'm not, just argue with me, right? Huh? Keep telling her. She wouldn't listen. And so, went to go hands-on. She pushed back, tensed up. So, still tried to...
Who was the guy?
Security. I tried to armbar. It wouldn't work. She was tensing up because she's a lady. Still trying to go as easy as I can. And she wouldn't. So, I leg hooked her, slammed her on the ground.
I saw that part.
Yep. So
what were you saying at first on the radio?
She wouldn't.
Seatbelt or?
Yeah, I went to go. I was like, so you'll see. So I went to go, tell her, hey, I told her the reason for the stop. Uh-huh. She was arguing. I wasn't doing 40 and 25. I wasn't doing that. So yes, you were. So and then she's like, I want to see it. It's like, no. Do you have your license? We went back and forth for a little bit. She kept trying to argue about it. I was like, all right, get out, right? And so she wouldn't. So I opened her door, went to go get the seatbelt. Well, she blocked me from getting it. And so I was pulling the Taser out. I hit the warning. She's like, all right, you don't have to tase me, dude. You don't have to tase me, dude. But then, in reality, I could have Taser with that one, but it just wasn't.
Yeah, the warning worked. Look at that.
Yeah, well, until we started having to wrestle on the ground.
Officer Hicks tells the other officers that he would have been within his authority to deploy his Taser against Ms. Sanchez-Rosas for refusing to comply with the exit order. Now, when evaluating whether an officer's use of force constitutes excessive force, courts apply the Fourth Amendment's objective reasonableness standard established in the 1989 case of Graham v. Connor, which directs courts to consider the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether the suspect is actively resisting arrest or attempting to flee. The Eighth Circuit applied those factors in the 2009 case of Brown v. City of Golden Valley, where an officer tased a passenger during a traffic stop solely because she refused to comply with commands to end a 911 call. The court concluded that it could not say that the use of force was reasonable as a matter of law, and that a genuine issue of material fact existed as to whether the tasing constituted excessive force, noting that the suspect had committed at most a minor misdemeanor, had posed a minimal safety threat, and was not actively resisting or attempting to flee. Critically, the court drew a distinction between a genuine threat to officer safety, which can justify force even in minor offense cases, and a mere affront to command authority. Here, Officer Hicks's own statements to his colleagues suggest that his motivation for drawing the Taser was to compel compliance with the exit order rather than to address any safety concern. And Ms. Sanchez-Rosas was suspected of a minor traffic violation, made no threatening movements toward Officer Hicks, and was not physically resisting. Accordingly, Ms. Sanchez-Rosas would have a compelling argument that deploying the Taser under these circumstances for the purpose of forcing compliance rather than addressing an immediate safety threat would constitute excessive force in violation of the Fourth Amendment.
No, I didn't check so.
Okay.
So,
Weird. you already get a code 11?
No.
17. Good job.
Thanks.
Hey, anything? Dan, you're good. You can thanks.
I don't know where her. Thanks, bud. Her glasses got bent up.
Car's really clean.
Yeah, I don't suspect it. She's just speeding. Made it way bigger than it needed to be. 10-4. That'll be the subject I'm 15 with. So, okay. It's all taken care of.
Did you get speeding, obstruction resistant?
Yeah. So, question.
Yeah.
And this is, as I understand the policy, I would have been green light to taser. But want to understand in this specific scenario. So she finally gets out after the warning. I holster the taser. We're talking. She's arguing. I tell her to walk back this way. She refuses to do it. I go to grab her. She pulls away. And she starts, and like I go to grab her again to armbar. She's strong arming it and won't comply at all.
Yeah.
But this one, I think I made the right choice.
That's active resistance, which in a situation you could, but like Garcia said, we shouldn't. I mean, you, the female, we shouldn't rely on the taser.
Exactly.
You can fight her.
Yeah.
Yeah.
I just want to make sure.
But yes, that's active resistance.
Okay. That would fit the policy if somebody was to ask. Yeah. Okay.
But yeah, that's cool. The warning that actually got her. That's kind of cool.
Yeah. She's like, oh, yeah. You'll see it on the body cam.
Officer Hicks asks another officer whether departmental policy would have authorized taser deployment during the physical struggle, and the officer states that it would, characterizing Ms. Sanchez-Rosas' conduct as quote-unquote active resistance. Now, while the department's taser policy is not publicly available, the legal distinction between active and passive resistance is well established. As the 8th Circuit Court of Appeals explained in the 2020 case of Cohorst v. Smith, the failure to follow police instructions may constitute passive resistance. And when a suspect is passively resistant, some lower level of force may be reasonable. Likewise, in the 2017 case of Tatum v. Robinson, the 8th Circuit made clear that non-compliance and arguing alone do not amount to active resistance, and that physically struggling, threatening an officer, or attempting to flee are the kinds of conduct that distinguish active resistance from passive non-compliance, with active resistance generally permitting a greater degree of force and response. To the extent Ms. Sanchez-Rosas physically opposed Officer Hicks during the struggle, a court could potentially find that her conduct crossed the line from passive noncompliance into active resistance under that framework, which could potentially justify a higher level of force and response.
Yep. Cool. I'm going to go ahead and transfer her to Benton County.
Okay. All right. Good. I'll do your inventory. I'll email you, and then it's all on keys, and it's not a push to start.
Yeah. 10-4. If you would assign me a CR for obstructing governmental operations. Do you have the car key?
I've got it, yeah.
Okay, cool. Real quick, there's no arguing it. You are going to Benton County, so don't start with that. But do you need medical assistance for anything?
No.
Okay.
Did you pick up my glasses?
Yes, I got your glasses, your phone. Your car key is going to go with the tow truck, but we got the keys off the car key itself.
Does it need to be towed since I'm not working?
Yes, it's going to be towed.
What's up? Oh, all right. All right, I'll take care of your record and
All right, thank you. Thank you.
After her arrest, Ms. Sanchez-Rosas was charged with obstructing governmental operations, speeding, and refusal to submit to arrest. There is little additional information available about this encounter, and the outcome of these charges is unknown. Overall, Officer Hicks gets a C- for threatening to deploy his taser on questionable legal grounds, escalating to physical force without affording Ms. Sanchez-Rosas a meaningful opportunity to comply or attempting to defuse the situation, and failing to exercise the kind of professional discretion that the circumstances warranted. The taser threat is the most legally significant aspect of this encounter. As established earlier, the objective reasonableness standard draws a meaningful constitutional line between a suspect who poses a genuine safety threat and one who is simply defying a command. And Officer Hicks's own statements to his colleagues confirm that his motivation was compliance, not safety. Whether that threat would survive Fourth Amendment scrutiny is, at minimum, an open question. Additionally, Officer Hicks failed to exercise exercise sound discretion, moving to physical force swiftly and without any attempts to de-escalate the encounter. Ms. Sanchez-Rosas delayed in producing her license and questioned the basis for the stop, but the footage does not show a stated refusal to comply. Officer Hicks moved to initiate a physical removal without pausing to allow her a substantial opportunity to respond, and the encounter deteriorated to a physical struggle and a takedown within seconds. Even setting aside the constitutional questions entirely, an officer retains discretion in how they manage a non-compliant traffic stop, and nothing in this encounter suggests that Officer Hicks made any effort to de-escalate the situation down before resorting to force. A brief, measured attempt to give Ms. Sanchez-Rosas time to comply may well have resolved the encounter without physical contact altogether. This interaction highlights that lawful authority and sound professional judgment are not the same thing, and that an officer's failure to exercise the latter can turn a routine traffic stop into a far more serious encounter than the situation required. Ms. Sanchez-Rosas gets a C for failing to comply with lawful orders during a traffic stop, prolonging a routine encounter through non-compliance, and physically resisting Officer Hicks after she exited the vehicle. And while Officer Hicks's conduct raises legitimate constitutional concerns, Ms. Sanchez-Rosas' actions also contributed to the deterioration of the encounter. As established earlier, a driver is legally obligated to produce their license upon demand in a lawful traffic stop and to exit the vehicle upon command, and neither of those obligations is conditioned on the officer first justifying the stop to the driver's satisfaction. Ms. Sanchez-Rosas disputed the alleged speed throughout the encounter and repeatedly demanded proof of the violation before she would comply, but the side of the road is not the appropriate venue for a challenge to the validity of a traffic stop. The legal system provides mechanisms, including contesting a charge in court, and a driver who disagrees with the reason for a stop is generally better served by complying in the moment and litigating later. And finally, the physical struggle presents the most serious concern. Regardless of whether Officer Hicks escalated prematurely, Ms. Sanchez-Rosas' physical opposition potentially exposed her to criminal liability. However frustrating a police encounter may feel in the moment, it is essential to understand that physical resistance carries legal consequences that a courtroom challenge does not, and that the decision to contest a stop on the side of the road rather than in front of a judge very rarely works in the driver's favor. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out Audit the Court if you're interested in exploring the legal nuance beyond the body cam.